Okay, the numbers seem to have steadied, so let's start so we can fit everything in. Okay, so I'm going to officially start the webinar. So welcome everyone to our Economic Crime and Corporate Transparency Act 2023 overview. I'll introduce myself. I'm Lisa Maynard and I'm the Claims Relationship Consultant for Zurich. And I'm joined by my colleague Becky Sutton, who's a Claims Relationship Manager. I'm really pleased to introduce our presenters today. So joining us from Zurich, we have Will Anderson, who's our Head of Commercial Speciality, along with Martin Sanchez Walker, who's one of our Senior Claims Adjusters. I'm also pleased to welcome DAC Beechcraft, and representing them today, we have Graham Briggs, Chris Dyke and Gareth Hall. All of our presenters today have a wealth of experience and knowledge in this area. So please, if you have any questions throughout the webinar, please pop them in the Q&A tab at the top of your screen, and then we'll get time at the end of the session to go through them. Okay, I think I've covered everything now. So I am going to hand over to Chris to start with the webinar. Thank you.
Great. Thank you very much and good morning, everyone. Well done for joining a talk about economic crime first thing in the morning. On this slide, we've set out what we intend to cover today over the course of this talk. So I'll hand over to Gareth first to set out the background and the background of the circumstances which have led to the changes which have been implemented by the Economic Crime Act, and some of the key highlights that appear in the Act that are significant for companies and partnerships. We'll then focus on two of the particular key changes which are implemented by the Act, and that is the reform of what's called the identification doctrine, look at the new failure to prevent fraud offence, what it means and what its significance is for companies and partnerships. And then we'll look at some claims examples to identify, to sort of flush out some of the circumstances in which these issues that we'll be looking at from the Economic Crime Act could crop up for businesses in the ordinary course of business. And then we'll have an opportunity for questions. So please do raise any questions during the talk. So over to Gareth to set out the background and the highlights.
Chris, Martin, you can go to the background slide. Thank you. Hi, everyone. So the Economic Crime and Corporate Transparency Act 2023, or ECTA, has been said to mark a significant legislative milestone in the UK's efforts to tackle economic crime and to improve corporate accountability. Its origins arguably lie in a growing recognition of systemic weaknesses in the corporate regulatory framework in the UK, including the misuse of legal entities and the difficulty that regulators have found in holding large organisations to account on a criminal basis. So there are several catalysts for reform, and they're sort of set out in brief on the slide, and I'll expand on them. They include high-profile cases that have driven the need, so the regulators say, the need for reform. In one particularly influential case, which involved bankers seeking to secure emergency fundraising during the 2008 financial crisis, the Serious Fraud Office prosecuting alleged that certain efforts made in order to secure that funding and communications to the market concealed the true nature of the arrangements, and that it involved side deals and additional payments which were not disclosed. There were a number of legal challenges in that case, including whether or not the dishonesty of the CEO and the CFO of the bank could be attributed to the bank itself under the prevailing identification doctrine, which Chris is going to talk about shortly. A company can only be held criminally liable if the individuals involved were considered to be its directing mind and will. The court ultimately dismissed the charges, finding that the executive's actions, even if dishonest, could not legally be attributed to the bank. And the regulators while not necessarily criticising the decision, criticise the backdrop to it, which is that the law does not provide a framework necessarily for them to hold complex organisations to account on a criminal basis, and that certain organisations might be in a position to evade liability because the individuals responsible may not formally be recognised as the company's controlling mind or directing mind. And so, again, the regulators and commentators argued that it exposed limitations to that doctrine and considered the need for a more effective framework for corporate criminal liability. In addition to that, and it's referenced there, the Law Commission review of corporate criminal liability and a couple of other consultations. These things highlighted broader concerns about the misuse of UK registered entities by international criminals. And the Law Commission 2020-21 consultation suggested that there were inaccuracies and abuse of information on the Companies House register, the exploitation of UK corporate structures for illicit purposes, lack of effective cross-referencing between Companies House and other bodies. And these issues, so said the Law Commission, painted a picture of a system vulnerable to abuse and one which was ill-equipped to respond to modern economic crime. And so the aims of the Act, the aims of ECTA, taken from explanatory notes to the legislation, are summarised really in 3 points. So 1, to prevent the misuse of UK corporate entities; 2, to strengthen the enforcement capabilities of Companies House, among others, including new powers to seize crypto assets, to facilitate information sharing, and to enhance corporate transparency through reforms to Companies House and to support legitimate enterprise. And the way that the Act seeks to do this is by introducing the major reforms that Chris has already alluded to. So the Companies House reforms, the new criminal offences, including aggravated offences for knowingly submitting false or misleading documents or statements to the Companies House, increased enforcement powers, and then the two reforms that will form the main subject matter of this session, which is the failure to prevent fraud offence, which seeks to hold large organisations liable if associated persons commit fraud for their benefit. And there's a quote there from Lisa Osofsky, the former director of the Serious Fraud Office, having referred to that offence as a game changer for law enforcement. Nick Fgrave, the current director, indicating that once it comes into force in September, they're going to be quite busy, perhaps. And then the second reform being the reform of the identification doctrine, so which I referred to in respect of that case law earlier. And again, Chris will go into more detail to broaden the definition of those individuals that can qualify as, quote, senior managers, in order to make it easier to attribute criminal liability to companies when senior personnel commit offences within the scope of their authority. So that's a bit of info on the background to the Act and the highlights. And so I'll hand back to Chris to talk about the identification doctrine.
Yes. So companies can only act through the actions of the individuals. Those are the individuals, the officers, the directors, and other staff and contractors who provide services for and on behalf of the company. So that means that in order for a company to be liable, there needs to be a way of attributing the criminal liability of the individuals to a company. Unless, and that's certainly the case, unless there's a specific corporate criminal offence that exists, for example, the bribery offence or the failure to prevent fraud offence that Gareth will be talking about. So in some cases, it can be very clear if an individual within a business has committed a criminal offence in the course of the business. For example, strict liability offences, which mean that there's no requirement to prove that anybody deliberately or recklessly did something through somebody's state of mind. So things like late filing of company accounts with Companies House, it's clear that the actions of an individual filing something late create a criminal offence and can be attributed to the company. In cases where it's necessary to prove a state of mind, dishonesty, intention, that becomes a much more complicated thing to do. And so there is this principle, which is known as the identification doctrine or the identification principle, which the criminal law uses to try to attribute the criminal liability of an individual to the company itself. The previous principle that was used for doing that was established by a 1970s case involving the sale of or the advertising of discounted soap powder by a supermarket store. It's sort of humble beginnings for what became quite a significant test. In that case, the supermarket was prosecuted for breaches of offence under the Trade and Descriptions Act because a manager of a local supermarket had failed to order enough discounted soap powder and displayed the sign advertising the powder, although none of the soap powder was actually available for sale to customers. The identification principle that was defined by the House of Lords in that 1970s case established that only the acts and state of mind of individuals who represent what is called the directing mind and will of the company can be attributed to the company itself. So that meant that only the individuals who are at the highest echelons of the management of the company can themselves be, or their criminal liability can be used to establish the guilt of the company itself. And that case defined the directing mind and will of the company as extending to the board of directors, the managing director, and perhaps other superior officers of the company who carry out the functions and management of the company and speak and act as the company. What that meant in the discounted soap powder case was that the company operating a nationwide supermarket chain couldn't be held criminally liable for the actions of its manager of one of the local stores. Some attempts were made after that case to try to tweak that identification principle so that it could be flexed depending on the circumstances of the particular case, but the courts kept coming back to that identification principle. And because of the limited circumstances in which that quite rigid test could be proven, it made it very difficult for larger companies to be prosecuted, and increasingly difficult in the modern day as companies become larger, become more sophisticated and complex, more global. And Gareth alluded to one of the cases, a recent bank case where that was quite a high-profile case in which that was difficult for the Serious Fraud Office to do. In addition to the statements then that Gareth mentioned, the same previous director of the Serious Fraud Office reflected on that previous test and said we have a very antiquated system. In these sorts of cases, I've got to have the controlling mind of the company before I can get the company in the dock. And that's a standard from the 1800s when mom and pop ran companies. That's not at all reflected of today's world. Surprisingly, the government have listened to that and have implemented quite quickly change, and that's in ECTA. And the ECTA position is then demonstrated is here on the second substantive bullet. What ECTA does is broaden the identification principle so that a company can commit an offence, a criminal offence, where the conduct that creates that offence can be attributed to a senior manager, so A, a senior manager, and B, who is acting in the actual or apparent scope of their authority. A senior manager is a person who plays a significant role, and this is on the third bullet here, a significant role in the making of decisions about how the whole or a substantial part of the activities of the company are to be managed or organised, or to the actual managing or organising of the whole or a substantial part of those activities. So whether an individual is a senior manager for the purpose of the legislation will be determined by what they actually do in practice. It won't be determined by their title, by a specific job role which the individual holds. The changes will apply to virtually all companies or partnerships, whether incorporated or formed inside or outside the UK. And unlike the failure to prevent fraud offence that Gareth will be talking about in a minute, this new rule of attributing criminal liability to companies is not limited to organisations with or companies or partnerships that meet certain size or turnover criteria. It applies across companies and across sectors. The expanded principle doesn't apply currently to all criminal offences. It applies only to the offences listed in the schedule to the Act. It's a fairly lengthy list of but mainly financial crime offences, including offences under the Financial Services and Markets Act, which will be of interest to regulated companies. But the government has already indicated the intention to expand that list of offences to all criminal offences. So that is looming and will become the principle that applies to all company criminal liability going forward. In terms of the effect of the change, its intention is to make it easier to prosecute companies for criminal offences and to avoid the difficulties that companies have had in the past of demonstrating that the acts of an individual should be interpreted as being a criminal act of a company. One could question whether or not actually this is sort of trying to crowbar criminal liability into an area where it doesn't belong, but the government's going sort of buying into that process and is trying to make that as easy as possible. It remains to be seen if the change will alleviate those difficulties. This test has been borrowed from a test that was applied in the Corporate Manslaughter Act, and that's been in place for many years now, and we haven't really seen many additional prosecutions of big companies as a result of that. So it may well not create a shift change, but it does indicate it's a clear statement of intent by investigators and prosecutors to say that we are looking to prosecute companies more and putting companies on notice to sort of really look at their systems controls to change culture in order to get prepared for that. And so if I hand over to Gareth to deal with the failure to prevent.
Thank you, Chris. So yes, and Chris's comments about the sort of shift change and whether or not that's likely to be seen again applies sort of equally to the identification doctrine expansion, but also to the new offence of failure to prevent fraud. One view might be that it's designed to close a long-standing gap in corporate criminal liability and to increase enforcement action. Another might be that it's intended to wave a sort of a stick which companies can avoid by improving their compliance and their systems. And of course, in order to do that, arguably you need to demonstrate willingness to enforce, and so it remains to be seen whether that will happen to then encourage companies to take note. So I'm going to explain the provisions in the failure to prevent fraud offence. Bear with me, there's a few moving parts here. I think we're going to come on to some more practical descriptions later, or ones that will elicit some of these concepts. But I'll run through the main provisions. So at its core, the offence applies where, and I've highlighted the concepts that I'll try to unpack as best I can in the time that we've got. It's where a person associated with a relevant body, which is also a large organisation, commits a fraud offence with the intention of benefiting, directly or indirectly, the relevant body or any person to whom or to whose subsidiary the associated person provides services on behalf of the relevant body. Quite a lot in that. So I'm just going to jump first of all to the third bullet point there. So person associated and associated person, to unpack what that means, that being the first concept in the summary of the offence at the top. So the definition of associated person for purposes of the offence has a kind of narrow, this will always apply definition, but also a much broader kind of catch-all provision. So the Act essentially says that employees, agents, and subsidiaries of the relevant body, come back to what that means, will always be associated persons. And then there's a catch-all provision which says that even if the person is not one of those three, then they will be an associated person if they perform services for or on behalf of the relevant body. Now, just to bring that to life a bit more, and it's partly the reason why there's a few additional types of persons or organisations in the list on the slide. The guidance that accompanies the Act when talking about what associated persons might mean makes reference to it not necessarily including scenarios where a person is providing services to a company. So it makes a distinction between providing services to and providing services for or on behalf of. And then it refers specifically to external lawyers, accountants, or engineers not considered to be providing services for or on behalf of. Now, it's guidance, query whether there aren't any possible examples where a lawyer or an accountant, for example, might be doing something for a company that the company could otherwise do itself that wouldn't necessarily be caught by that. Of course, whether those types of variations come out will only be clear once there are some cases there. So that's the first sort of bullet point to meet, if you like, is that the person committing the fraud offence must be associated. They must be associated with the relevant body. So relevant body and one which is also a large organisation. So relevant body, first of all, means a company or a partnership, wherever incorporated or arranged. So an extraterritorial element there, which I'll come back to later. And they must also qualify as a large organisation, which means they must meet at least two of the following: more than 250 employees, more than £36 million in turnover, and more than £80 million in total assets. So at least two of those three things. And the financial elements are to be calculated by reference to the financial year in which the fraud offence is alleged to have taken place. So the sort of the point to make there, I think, about the reason for there being a relevant body but also a large organisation concept is that, as we'll see later when I talk about some of the key takeaways here and some of the practical examples, there are scenarios in which a person associated with a relevant body which is not itself a large organisation may, where there's a fraud offence committed, might actually create criminal liability in certain circumstances, for example, where the relevant body is a subsidiary of a large organisation. So there are some sort of variations there. And again, it sort of reflects the fact that companies, for example, that are part of a group, or companies that have complex supply chains, or distributorship sort of arrangements or whatever it might be, needs to be aware of compliance along the whole of the chain, because there is a risk, assuming that there is a large organisation involved somewhere at the top, that criminal liability could result if fraud offences are committed throughout that supply chain. Just going back to the associated persons point, so I mentioned the sort of specific scenarios and then the sort of catch-all provision. The key point here is probably the provision in section 1999 of the Act, which says that whether or not the person performs services for on behalf of will always be a matter of fact based on the circumstances, and will not simply be a case of just looking at the nature of the relationship. So you might look at a commercial contract. The commercial contract does not necessarily mean that they are automatically associated. A court would look behind that and consider the facts as a whole. So I'm going to come back to that point of extraterritoriality. when I talk about takeaways. So if we could just very briefly, just to explain what's meant by a fraud offence. So we're talking about it's a much shorter list than those that apply under the identification doctrine, which is a list of economic crimes. For these purposes, we're talking fraud, false accounting, and a couple of other sort of distinct offences, but not a broader range of economic crime. So those will not apply for the purposes of this offence. So we go on to the defence slide. Thanks, Martin. So this is the promotion of compliance point. So a relevant body, so the relevant body that's the large organisation, will have a defence to the offence of failure to prevent fraud, where it had reasonable prevention procedures in place at the time of the offence, or it was reasonable not to have such procedures in place. So that creates an evidential burden on the company to show that it had reasonable prevention procedures in place at the time, and the sort of guidance that exists to explain what reasonable prevention procedures means is very similar to the type of guidance that we saw for failure to prevent bribery and also failure to prevent tax evasion, which is essentially follows a framework guided by those principles there. So we have top level commitment, so do the senior executives, do the leadership, endorse it, understand it, communicate it. Has there been a risk assessment to identify where those risks exist along the supply chain and with providers and agents? Are the prevention procedures proportionate? Is due diligence conducted? Are the procedures communicated business-wide, and are they monitored, reviewed, and amended as appropriate throughout their lives? The two that I've highlighted there, risk assessment and due diligence, I've done that because I think that those are the things that we see companies perhaps struggle with the most. So the assessment of risk on a business-wide basis is very difficult. How do you start? What do you look at? That's something that people sometimes struggle to get over that initial hurdle, but that's where it all starts, to identify what we need to do. And due diligence quite often crops up. You know, we've done this, and this. Do we need to go any further? Have we done enough to demonstrate that we've used reasonable procedures? So that's another thing that sometimes we see. Quickly before I hand back to Chris, I think I just wanted to highlight a couple of it's not on the slide, but there's some special considerations or key takeaways. So I think the key point on this offence is that its implications are very broad. So I spoke about the possibility that a subsidiary of a large organisation could still be caught by the offence. So, you know, if they are owned by a large corporate, wherever that large corporate is incorporated, then they still have to worry about this because it potentially creates liability. There'll be group level, sort of changes in how systems are run and due diligence and all the good stuff that's on that slide there. I mentioned extraterritorial reach, so parent company incorporated overseas, and the need for that global coordination of prevention procedures. There's also the possibility that if the triggering fraud offence occurs abroad, so long as there is a UK nexus, a sufficient connection to the UK, such as part of the offence taking place in the UK, or perhaps the gain or the loss occurred in the UK, then that conduct will still be caught by the Act. And I think the other point really to mention is even where smaller organisations perhaps are not caught as a result of being owned by a large organisation and not being a large organisation themselves, it's likely, and again we'll come back to this on some of the practical examples, that they will be required by the bigger companies that they work with to do more in terms of fraud prevention. And certainly guidance encourages smaller organisations to adopt the same principles as a matter of good practice in any event. So it matters across the sort of breadth of corporate entities in the UK. So with that, I'll come back to Chris for the timeline of changes.
Yes, and so this we'll cover off briefly is just to give a high level view of the sort of systemic changes which are being implemented being sought to be changed by ECTA. ECTA is pitched as being a landmark act intended to really just change the information that's available to regulatory bodies like Companies House to make it easier to identify criminal offences in the course of business, and then to support those prosecutions and investigations when they are underway. This timeline, so because of the landmark nature of it, because of the complex nature of what this act is seeking to do, it's being implemented in phases. There are parts that are already in place, there are parts that are shortly coming into force, and then there are other bits which are just projected going into the future. And this slide here picks out demonstrates some of that. So the Economic Crime Act was introduced, it was enacted in October 2023. The identification doctrine change, which I talked to just now, is in place and has been in place since December 2023. So companies should be looking now at what impact that has on their business, principally speaking, looking at who within the business might be considered a senior manager, looking at what systems, controls and training need to be in place in order to make sure that senior managers are aware of the liabilities, and making it expressly clear what each of those individuals' actual or apparent authority is. In that sense, ambiguity will only increase liabilities for companies, and it's worth looking at now if that hasn't already been considered. In November 2024, the government guidance on the failure to prevent fraud was introduced. That's what Gareth was talking to just now, and that has a lead time to be implemented in September 2025. So September this year, a few months away, and that was intended to give companies time to read the guidance, look at systems controls, training, etc., their risk profile, what due diligence they're going to undertake, and to implement that so that it's in place on the 1st of September, and then companies can benefit from that failure to prevent defence in the event that inadvertently offences are committed in the course of business. But against that backdrop, there are these other changes which are in the slightly less stark grey colour on that slide, which demonstrate that alongside all of this, there are changes being implemented in the way in which Companies House is able to gather information, which will support how it can identify criminal offences proactively and verify data and shut down companies where Companies House is concerned that companies are being used to commit financial crime. So that there will be increasing burdens on business in the way in which companies can be started, what information Companies House can require to incorporate companies, what information is required, and who can submit information to Companies House going forwards in terms of filing information with Companies House on an ongoing basis. So those regulatory burdens for business are going to increase going forwards as well. So, I mean, that I suppose gives a perspective on sort of what is changing and how. And so if I hand over on what the practical examples, I suppose, of what that means on a day-to-day basis.
Yes, thanks, Chris. So as we've hopefully sort of covered off, the ECTA introduces some new offences, but also expands existing offences, and a lot of the issues we're talking about, of course, are not new in terms of criminal prosecutions for fraud offences. But what we try to do is just give some examples and a couple of slides of how we think the ECTA will interact with some of these existing offences and some of the new offences as well. So the first example put up there relates to actually some of the sort of regulatory requirements that Chris sort of touched upon. We haven't got time to cover all of these off today, but in terms of extra burden on companies in relation to what they file and how they file certain records of Companies House. So I should say some of these claims examples are based on, or loosely based on some claims we are dealing with or have dealt with in the past. So the first example is a company, and in this case, let's say it's a medical services company, has 2 directors and 2 equal shareholders, and the company has filed misleading shareholder information. And without getting too technical, companies are required to disclose what's called persons with significant control, so typically essentially shareholders, all major shareholders in the business, when they make annual filings at Companies House. And in our example, one of the directors made a filing knowing that it was incorrect. And the background to that is that one of the directors, and who was also a shareholder, was imprisoned, which is obviously bad for business. And they were trying to work out what would happen with that person's shareholding in directorship. Nothing was formally agreed, but notwithstanding that, the other director took steps to essentially remove them from the shareholder register. So they made a filing that was incorrect. Companies House identifies this and investigates it as being suspected of fraud, refers it to the Secretary of State's criminal enforcement team. So what does that mean for the company and the director? So dealing with the director first. So previously, before ACTA, it was an offence to knowingly or recklessly file information that was either misleading, false, or any other sort of documentation at Companies House. What ACTA has done is it's removed that one for knowingly or recklessly. So it's essentially a strict liability offence. There is a sort of get out or defence to that, which is if there is a what's called a reasonable excuse. And obviously we'll have to see how this sort of plays out in terms of what constitutes a reasonable excuse. But in the explanatory notes in ACTA, they suggest that it's intended to carve out instances where a company relies on information provided by professionals, for example, which turn out to be untrue and it's an honest mistake. Both the company and the director can be held liable. The offence is punishable by some limited fine in England and Wales. And the ACTA also introduces an aggregated offence, which is where someone knowingly delivers documents to Companies House that is misleading, false or deceptive. There is no reasonable excuse component for that, and there is an additional potential punishment, which is up to 2 years imprisonment. So can be quite a serious offence. So this is just an example of where the Act expands existing duties on companies and directors to make proper filings in Companies House and the potential implications of that. The next example we've put up on here is this, hopefully to sort of demonstrate how the identification doctrine might work in practice. So the example we've got here is a commercial manager of a business. And let's say this business is a perfume business and is selling products all over the world. The commercial manager arranges products to be sold in Russia in breach of Russian sanctions. The Office of Trade Sanctions Implementation identifies this issue, and starts an investigation. What does this actually mean in practice? So the director, also it's not director, the commercial manager, who's not a director, is potentially criminally liable under sanctions regulations. They may also face a civil liability in that regard as well. And under the identification doctrine, the company can also be liable. So the actions of its commercial manager is now much easier for the reasons that Gareth Crystal was about, to attribute those actions on the company itself under the identification doctrine. So that's a sort of example where we can see an expansion or increased liability for the company. What we aren't really talking about for the purpose of this, but is worth noting, is we're talking primarily in a sort of regulatory criminal offences, but often what we see then is other litigation. So in this scenario, for example, you could find a scenario where the commercial manager as an individual faces civil action by the company against them, or if he was a director, might be a claim for breach of director duties, for example, for any losses the company suffers as a result of their actions. So often, once you have regulatory or criminal actions, there can be sort of satellite litigation that follows, civil litigation as well. So worth bearing in mind. So I think it's you. So I've also put an example about information requests that the SFO can make. And The example we've given is SFO compels a company to provide information, and it relates to them deciding whether to open a criminal investigation. The company fails to respond, and that is a criminal offence. Now, in practice, information requests can be made against a company or quite often against individuals. So directors, as the sort of voice of the business, can be asked for this information. It's a criminal offence, both the director and potentially the company as well. The real sort of key point with this, though, is that what ECTA does is it expands the circumstances in which the SFO can ask for certain information or require companies or directors to provide information. And that information is or the power that they have under the Criminal Justice Act. And for ECTA, they could only ask for information once they've already made a decision to commence the investigation. And there was very limited circumstances where they could ask for information in what's called a pre-investigation stage. And that was if there was international bribery or corruption. What ECTA does means that the SFO can require individuals or companies to provide information before they've made a decision to investigate. So that's quite a expansion on those powers. I think what that means in practice is we're going to see more requests or SFO requests for information under the Criminal Justice Act. It's a much lower threshold for them to get over in terms of being able to ask for that information. And therefore, companies and their directors are going to need advice more often on these types of issues because of this expanded powers. Finally, we've put up an example in relation to associated persons. So the example given here again is loosely based on the case we're dealing with, but an insured company provides distribution services to a large organisation. And large organisation in this context, I mean in this definition of it's allowed for under ECTA. And the insured director and the insured company, I should say, is an SME. The insured director is complicit in a supply chain fraud, and what they do is they fraudulently record shipping records that has the effect of reducing a large organisation's VAT liability. So it's primarily the large organisation that benefits from it. What does that mean in practice? So the director can be held liable both by the civil or criminal liability for its role in the tax fraud. The company is also liable because the individual is the director. It would be much easier to attribute their actions to the company anyway, but you absolutely certainly can under the new identification doctrine. But also crucially, the large organisation, so the SME's client, in fact, may also be liable for failure to prevent fraud on the basis of it didn't have inadequate steps or procedures in place to prevent the insured company as an associated person committing fraud. And it'd be interesting to see how some of these sort of claims play out in the future. One of the things that might be interesting to see is you could easily see how a claim could arise against an SME from a large organisation if, for example, the SME is under a contractual obligation to put in place certain processes or procedures to prevent a fraud. They don't do that, and the large organisation then potentially faces a claim for that offence. We'll have to see how that sort of all plays out, and there will obviously be lots of arguments that have both sides of that, but a potential issue there as well to bear in mind. That's all the claims examples we had. I did see a hand raised if we I potentially saw the screen, but I missed that if there was a question. No, we'll wait till the end.
Yeah, thank you. Firstly, thank you to Chris and Gareth and Greg for walking us through the details of the Act and those illustrative data examples. And good morning, everyone. I think in the time that remains, Will and I are going to go through and look at some of the policy issues, broader implications of claims. So these legislative changes will ultimately make it easier for companies and directors to be held accountable for their actions. We therefore expect that the new offence will lead to an increased frequency of investigations into companies and their practices. There may also be increased scrutiny of directors responsible for ensuring reasonable procedures are in place to prevent fraud. However, these aspects of corporate governance, I suppose, are likely already a consideration for many companies, including in their risk management and insurance controls. So it turns us on to the Zurich ERS policy. And for those who are not familiar, our executive risk solutions, charity executive risk solutions, or ERS policies, are Zurich's management liability product designed to specifically protect directors and officers and their businesses or organisations, covering financial loss, including defence costs, damages, and settlements. For context, the policies provide 5 core coverages, including D&O liability, corporate legal liability, employment practice liability, benefit plan liability, and crime. So how might management liability policies respond to claims related to an alleged failure to prevent fraud? Well, typically, insurers involved will be providing cover for defence costs in responding to claims or investigations arising from an alleged failure or wrongful act. The ERS policy wording provides wide cover for both insured persons and companies. This includes cover for claims where regulatory proceedings or civil claims are commenced, and or for investigations. In the examples that we've talked to earlier, there would likely be cover for both the directors, or directors both in relation to an investigation against them, or alternatively where they are asked to provide information on behalf of a company or to attend a compulsory interview. This is because where a company is being investigated, it is the directors that usually have to answer the questions. And this could be under caution through PACE interviews, for example. The definition of insured person is interesting. Under the ERS wording, or wordings, the definition of insured person is also very wide, extending to include those who aren't directors, such as employees acting in a managerial or supervisory capacity for the company. In Graham's earlier example of a sanctions breach, the individual involved was a manager, a commercial manager, so not a director. However, they would still be covered if acting in that managerial capacity. And beyond the principal insuring clauses of the policy, there is wide-ranging cover in the extensions. One relevant example might be the additional cover for reputation and recovery costs, which provides cover for the costs of engaging an outside public relations company as a result of a covered claim. Similarly, the crime section of the policy may become relevant if an employee has been stealing from the business or some other act of fraud or dishonesty committed by an employee is discovered. And Graham did mention this earlier, but so far we've talked mostly in the context of a breach of the company's obligations or regulatory claims, but often civil claims may follow. For example, claims by the company against the directors for any losses that result from their failings, or claims by the shareholders. In principle, there is cover for those claims too. And in the early example, where the company was fined for a failure to file company house documents in time, here the director responsible could face a claim for breach of duty and losses, which may include the company's costs and any fine levied against them. Lastly, just picking up public policy and conduct issues. As you're no doubt aware, it's not possible to insure against illegal acts, but how the policy deals with this is through final adjudication language. And this means there is cover until such time there is a final determination, for instance, either a finding against the insured or a written admission by such insured. And ultimately, this means that insurers continue to support the insured by advancing defence costs and providing access to our network of specialist solicitors and experts, some of whom we've heard from today, and also benefiting from preferential panel rates, which ultimately helps to protect the policy limits. And this is important, as clearly higher rates will erode limits sooner. That was all I planned to say on policy, but I'll now hand over to Will to discuss the broader implications of claims and potential costs involved.
Yeah, no, thank you, Martin. I think it's my perspective, it's important to hear, and we've heard this from Chris and Gareth earlier, that the new offences make it easier to bring claims. But these types of claims are not new. Investigations have been out there previously. In terms of the topics I'd like to talk about, it's just a couple of issues really. One is the timing and the resource that our customers and businesses will have to put into this if they're facing an investigation. So at the top of the slide there, you can see this is the FCA published numbers as such. This goes back a little bit of a way, but as you can see, if you look at the average length of time it comes to get to an agreement on something during a regulatory action, that is up to 3 years. And if you go through a full-blown investigation, you could be looking between more 5 to 6 years. So the implications on that is very harsh on the business in terms of the documents necessary to prepare defences that would be available. So I think it's really important to understand, you know, the impact that these types of cases can bring on both the individuals and the business. And then secondly, I just wanted to focus more on defence costs. There are a couple of high-profile cases out there which we've been dealing with, and they start in terms of regulatory actions, but they're also run in parallel with civil actions. These have resulted in a couple of significant fines that run to the tune of tens of millions, but also the most important thing is defence costs associated with getting a case to that level and maybe resolving the issues as such. We've seen a couple of public cases that have been published recently in terms of 2 clients as such, where it has run to tens of millions of pounds in terms of defence costs. Now, turning to smaller businesses, we've seen a couple of examples in that. One was a waste management company where we've seen alleged tax fraud and money laundering. And again, that has run to nearly £3 million in defence costs. And then another example was a family business where there was alleged fraud in terms of postal services. And again, that runs to £2 million in defence costs incurred. So as you can see, these regulatory actions are really high level in terms of the cost associated to a business. So there's a couple of things I would just like to flag. I think it's really important that the customer and broker base work very closely with Defence Counsel and also insurers in bringing and speaking about these defences and claims that exist and making sure robust budgets are in place to see it through so there's no surprises. And then the other piece is with the costs increasing, I think it's very important that we also look around the kind of robustness or sufficient coverage limits available for defence costs. So that's another takeaway I would take from the examples that we're seeing. So I'm very mindful of time. We've obviously got some questions appearing. So if I could hand back to Becky, just to cover off now the questions that may have arisen on the chat. Thank you.
Thanks, Will. That's great. And thanks to everybody. Very informative and interesting session there, I think. There is a QR code on the screen. If you wouldn't mind having a look at that, that's the feedback form. I have also just put in the chat the link as well, if it's easier for just click on the link. So we would appreciate any feedback that you can give us on this as it helps us tailor future events as well. So we've got a couple of questions that have come in. Let me just find the question. So the first one we've got is, would universities, government, organisations, etc. be classified as a relevant body if they hit the large organisations thresholds but are not a company or partnership?
just start that. I think so. The offence applies. I think the offence applies to incorporated organisations and partnerships, however incorporated. So there are certain ways of incorporating that don't involve incorporation under the Companies Act. It doesn't apply to unincorporated companies. So I think the answer on that basis would be that to the extent that there would be an incorporated entity involved in those types of organisations, then yes, assuming that they met the large organisation threshold. Of course, in some of those examples there wouldn't be, that there has to be that incorporation or partnership involved. Otherwise, the offence will not apply. Chris, you got anything to add?
Yeah, that's right. And so, university bodies might be bodies called incorporated companies. So it might be companies, they might be charities. Yeah. Charities are caught by the failure to prevent fraud offence.
Brilliant, thank you. Next one, we've got, will the policy also protect insured persons against claims or allegations brought by the company?
Yeah, you go first.
I think the short answer is yes. So as Martin sort of touched upon, the covers quite wide ranging. So it includes regulatory actions or criminal actions as well as civil claims. And so some of the sort of concurrent civil claims we talked about, we would expect the policy to respond subject to all the other terms and conditions, obviously. But the short answer is yes. That's quite a common claim that we see from companies against directors.
Okay, thank you. And we've got one here. In large privately owned groups where responsibility for day-to-day activities is not directly managed by the directors, how do those directors get comfort that they are not personally at risk from activities not managed by, well, it says by there, but I think they mean them, but for which they are liable?
I have to start. I mean, yes, the starting point, as Gareth said, is looking at your systems controls and reviewing your business. So government and prosecutors accept that no individual within a business can be on top of everything that's happening within the business. They can only, global businesses mean that you need to put in place certain systems in order to enable that business to function properly, function autonomously where it has a footprint, but also to just maintain oversight and supervision and monitoring to a reasonable extent. And so directors, in order to manage their own liabilities, should embark upon a risk assessment of the company to identify where there might be risks in the course of business of individuals committing offences, and then to put in place training, so as to train them, make sure those individuals know what the obligations are, put in place clear statements about what the expectations of conduct are, and to put in place measures so that there is a degree of monitoring and oversight, so reporting lines and systems, so that there is checks and balances in place and over the areas of the business where there is identified to be a risk. That doesn't mean that a director needs to be personally looking at everything that everybody's doing, but I suppose at the very least needs to be able to say what their awareness is of the systems they've implemented to try to guard against that happening. And then if a fraud offence does get committed in the course of business, well, you can't eliminate the risk of that, but you can demonstrate that you've taken reasonable steps to seek to do so.
Brilliant, thank you. Well, I think that we've just gone over time there, so we've completed that pretty well and got to all the questions that have been asked. So thank you again for everybody that's attended and to our speakers. We will obviously send the recordings out. There is details on the last couple of slides of contact information for the speaker. Should anybody have any additional questions, please feel free to reach out to anybody that's been involved, or myself and Lisa, and have a good rest of the day. Thanks again, everybody.
Thank you.
Thank you.